Hello and welcome to episode 48 of Not Reserving Judgment, a podcast about the latest intrigues, triumphs, and outrages in Canadian constitutional law. I'm Josh Dehaas, counsel with the Canadian Constitution Foundation.
And I'm Christine Van Geyn, the CCF's litigation director. Joanna is away. In today's episode, I'm going to tell you about a recent Supreme Court decision that found, just as we at the CCF had argued, that there is no absolute immunity for Parliament when it passes clearly unconstitutional laws.
And we'll share our bad legal takes of the week, where we take a lighthearted look at some legal opinions that didn't quite land. But first, since Christine's going to be celebrating a win, I'm going to tell you about a loss, one that we just found out about yesterday, so it still kind of stings. Over the past few months, among other things, I've spent a lot of my time working on this proposed intervention in a case called Canadian Coalition for Firearms Rights, which is a case we talked about before on this podcast a long time ago. And the case is an appeal of an October 31st, 2023 decision in a judicial review of the Trudeau government's May 2020 order designating certain makes and models of firearms as prohibited, which they're allowed to do under the criminal code if, in their opinion, the firearms are not reasonable for hunting and sport. And the CCF was interested in this case mainly because the governor and council, that is federal cabinet, banned not only this list of firearms, but also any variants or modified versions of those guns, which is where the real problem lies here for us. So the reality is no one seems to agree on which firearms actually count as variants. And, this is a problem because not knowing in advance whether your gun is prohibited is potentially going to lead to criminal charges, which are extremely serious. They can basically ruin your life if it turns out that you're wrong about whether your gun is legal or not. And to get around this, the RCMP had created a database where they list all the guns that have been tested in their labs so that cops and prosecutors can look at this database and figure out whether or not a particular make or model is prohibited or not. And this is called the Firearms Reference Table. And the FRT has been around for a long time, and initially it wasn't available to the public, but since it was pretty obviously unreasonable for the RCMP to keep secret its list of weapons that it considers illegal, they started making it available to the public. And the issue comes up if you own a gun and maybe you disagree with the RCMP over whether or not its listing on the FRT is correct. So according to the evidence of the federal court, you could ask the RCMP nicely to change their designation, but there's no formal process to challenge their decisions because in the RCMP's opinion, they're not really making a decision about which gun is legal and which one isn't. They're just creating this interpretive aid. And so the federal court determined that when guns are listed on the FRT, the RCMP isn't making any law. It's just creating an interpretive aid. So finding that the RCMP was not making any law when deciding whether or not a specific gun is prohibited was key to the judge's finding that cabinet had not unlawfully subdelegated the authority given to them to decide which guns, ought to be banned because they're not reasonable for sport, shooting, or hunting. And in other words, this was really key. And so, we plan to intervene to make basically 2 points. So these were points, by the way, that were not likely to be made by either the gun owners, who only win on this point if they can convince the judge that the RCMP's listings are making law, or the Attorney General, who can only win if they convince the court to uphold the lower court's rulings that the RCMP's listing of guns is a mere interpretive aid. So first, we plan to say that if the FRT is law, as the firearms owners assert, then the principles of rule of law, the hierarchy of laws, and constitutionalism lead to certain conclusions. And one of those is that you need to be able to formally challenge that through judicial review. And we also said, if the court finds that the FRT is not law, that the RCMP is not making law here, as the AG asserted and as the judge at the federal court level found, we want to make the point that this can only have limited weight then. The FRT can only be worth, as the other lawyer working on this put it, worth as much as toilet paper, basically. Like a gun owner should be able to still go to court and say, is my gun prohibited or not? And the FRT shouldn't have all that much bearing on that decision. So we thought it was important to be at this hearing to make these arguments because, the applicants were not necessarily going to make them. They want to win in any way they can, and the AG wants to defend their gun ban at all costs. But sadly, the court rejected our proposed intervention, meaning we can't go to court and actually make these arguments in person. And it was rejected for two reasons. So first, the court said our submissions wouldn't be useful to determining the issue of whether the FRT is or is not law. And basically, we didn't take enough of a position on that, but we would obviously disagree. And the point of interventions is not necessarily to take a position, it's to put forward, other cases and help look at the issue in a different way. So we disagree with that. The other issue was that they said we should have filed this sooner. And sadly, it took weeks and weeks to write this motion, and then it just got rejected almost immediately after, partly because of this delay issue. And the funny thing is, on that latter point, that we should have filed this sooner, basically the Attorney General had put forward evidence claiming that we'd known about this for a long time and we should have intervened sooner. So they got to file evidence, and then we tried to file evidence in response explaining the sort of behind the scenes stuff that led to us being a little bit delayed, and the court said we weren't allowed to file evidence, which is very frustrating because I think they're basically saying if you're late, you have to give us a reason.
But Josh, you forgot to mention what some of the evidence they filed about our lateness was, because I think it's relevant to listeners of the podcast.
Well, the evidence that they filed was we knew about this since November because we talked about it on the podcast, which is absolutely true, but we didn't know in November, who else would intervene, and you're not supposed to waste the court's time by duplicating.
We didn't know if we wanted to intervene.
Yeah, we didn't even know, if the appeal would be heard necessarily. And then there were some other internal issues we don't need to get into that just led to delay, like things that just happen and are normally accepted by courts, but we weren't allowed to file evidence after the AG filed theirs. So that's unfortunate. But I just want to say to all the people out there who, care about the rule of law and property rights, who think you should be able to know in advance whether your gun is illegal before the cops come and knock at your door, or who think that the government, if they're going to make property illegal, should at least, put that in writing in an order in advance rather than leaving it to the RCMP. Just know we tried, and there is a silver lining here, which is that the other interveners, which are Alberta and Saskatchewan, they got all of our materials. So if they want to make some of these arguments that we put forward, maybe our materials will help them when they're in court. So any reaction, Christine, to this unfortunate, sad loss? And
it's too bad. I think I think it's
win?
also typical of the federal court and federal court of appeal. They're less friendly to interveners. They're less likely to give interveners. My favorite part of this is imagining how lucky that articling student who got to listen to hours of our podcast to find this evidence to include in the appeal. What an amazing, lucky job that is. Congratulations. And I hope to anyone else listening at the AG's office, stop doing illegal things, stop defending bad laws. I mean, I guess that's sometimes your job, but
I'm sure they see it differently.
I'm sure they see it differently, but listen to our podcast more. Maybe we'll change your mind. So now I want to get to my news headline, which is about a decision that just came out from the Supreme Court in a case that we intervened in. It's a case called RV Power. And in that case, the federal government had argued that they have absolute immunity from being sued by citizens hurt by unconstitutional laws. Even once that law has been struck down, the government in Ottawa is saying, actually all the governments were saying that people hurt by those laws are not entitled to sue. Never. They're never able to sue. They have complete immunity. Even in cases where the law was clearly wrong and abuse of power or enacted in bad faith, which, by the way, is a very high threshold. And we thought that, that position is indefensible. It's completely wrong. The government needs to face consequences for unconstitutional laws. And one of those consequences can be, in some circumstances, a lawsuit for damages brought by the people hurt by that law. So we argued as an intervener that when that very high threshold is met, when the law is in bad faith, clearly wrong, or an abuse of power, then you can sue. And there's no absolute immunity. And the majority of the court agreed with our opinion. So let me tell you a little bit about the background of the case, even though the background isn't really relevant to the question that the court considered here, but I'll tell you anyway, because people, love the facts of cases. So the case is about a man, his name is Joseph Power, and he was convicted of sexual-based offenses in the 1990s. He served his time, and then he became an X-ray technician. He was working at a hospital, and he looked into getting a pardon for his offenses. But by the time he got around to looking into this pardon, the regime for granting pardons had changed, and there was now a new federal law that prohibited him from getting that pardon. And it eventually came out at his place of work at this hospital that he had a criminal record, and his employer fired him as a result. And he then couldn't get the pardon. And eventually the law that was prohibiting him from getting that pardon was struck down as unconstitutional. But by then he had lost his job, he had lost his income, and he wanted to sue the government for the damages, losing his job and his income, from their unconstitutional law. And the question that went to the Supreme Court in this case was, can he sue? And the federal government said that they have absolute immunity from all liability when performing a legislative function. But there's actually existing law, a case called Mackin, it's about 20 years old, that says you can sue for an unconstitutional law, but only in narrow circumstances where the law was in bad faith, an abuse of power, or clearly wrong. And it's important here to distinguish between suing the government for unconstitutional acts by government agents or the executive versus suing for unconstitutional laws enacted by Parliament. Because we're all familiar with lawsuits for the first type of liability, executive action or state action. Suing for police brutality is like the typical example, or even the lawsuit for the executive act of the Trudeau government freezing bank accounts. That was an act of cabinet, it was an act of the executive, and people are suing for damages for that. But what if you have damages that flow from the passing of a law itself? Now, we'll go through a few hypotheticals so you can understand what that might look like, because we actually have these in our history. This is not, like a purely speculative exercise. Canada has enacted bad laws that have hurt people just by the passing of the law. So we have the example of the internment of Japanese Canadians. This was done by law and then by executive act. We have the banning of Indigenous potluck ceremonies. We have the forced sterilization of Indigenous women. In fact, there can be damages that flow even from the law itself, even if government action has not yet been taken. So let's use the example of the internment camps. The legislature passes a law that's saying people of a certain race or religion will be sent to an internment camp. And even before they start sending people to those camps, people may take action. In fact, they're very likely to take action before the state enforces that law. They may relocate. They may sell their possessions and property. They may do things before the government actually enforces that illegal law. Let's look at another example. The forced sterilization example, which also happened in Canada. If the legislature passes a law like that, people may, again, they may move, they may go into hiding, they may preemptively do things to their bodies and their fertility to preempt the state taking action, which could have lifelong consequences, for which I think they should be able to sue for damages. Let's consider another example, which is one I've given when talking about this case. It's something called a bill of attainder. And bills of attainder used to get passed in England, back in the 1500s, 1400s. These are acts of the legislature declaring that a person, a specific person, or a specific group of people are guilty of some crime and punishing them, often without a trial. So a bill of attainder might say, Josh Dehaas is a very bad person. No one should speak to Josh. No one should give Josh a job. He's a pariah, and maybe we should execute Josh. You might think, Oh, bills of attainder, that's an old thing from England, but Parliament has twice tried to pass bills of attainder, not against nice people like Josh, against notorious murderers, but still, they have tried to pass them. And maybe you might think because they're notorious murderers, it was Karla Homolka and Clifford Olson, where Parliament tried to pass bills of attainder. You might think, those aren't good examples because, we do dislike those people. But the thing is, that's just not how our system's intended to work. And we should be concerned that governments have a history of passing laws that are abusive and are in bad faith. And this is a very high threshold. So how would you feel, listener, if the government passed a bill specifically targeting not Josh, but you, or targeting their political enemies, or someone who might just be unpopular in the mainstream, but that you happen to like for some reason? I want to come down on the side of limiting government's power to do this kind of thing. And the state has never been entitled to absolute immunity for claims of damages. And individuals have a right to sue when this high threshold set out in that old 20-year-old case of Mackin has been met. And the Supreme Court affirmed this. Now, Mr. Power can try to sue for damages. Look, I'm actually skeptical that his case meets that threshold of clearly wrong, abuse of power, or bad faith. But the point is, he can try. There's no absolute immunity for the government. And the thing that's been interesting about this case is, look, I am on record as a skeptic of judicial power, and that's one of the things that people have been criticizing about this case. They're saying that this case undermines parliamentary power and parliamentary supremacy. But I'm just a skeptic of power generally. I'm a skeptic of judicial power, but I'm also a skeptic of parliament and politicians. And I don't want there to be unlimited immunity the way the government was proposing here. And for those of you listening who don't trust judges, and I agree, why do you trust politicians with unlimited immunity? So my bad legal take this week, you're gonna have to wait to the end to hear it, but it relates to this dispute. So let's take a break now, and then we'll come back and we'll do those bad legal takes. And Josh has a little other update to give as well.
Yeah, so before we go to break, I just wanted to remind everybody that you should go to our show notes or the CCF's website and take our very short 2-minute not reserving judgment survey, just so that we can get some valuable feedback on how we can improve this show, which is nearing its 50th episode. Yeah, so please go and do that survey. We'll be right back. Okay, so straight over to bad legal takes. I'll go first. So my BLT goes to the Edmonton Police Commission, which has a new policy aimed at keeping annoying members of the public from showing up at meetings and criticizing them. And this BLT is based on reporting from the Edmonton Journal, which reports that apparently Edmonton City Council and the Police Commission have been in some sort of spat for months over whether the Police Commission needs to share a list of audit priorities with them. And it looks like this new policy maybe relates to some of the criticism they've been getting over that, although it's not entirely clear because they've been getting lots of other criticism too. So I read the briefing note that proposed this new policy, and it says all members of the public in attendance are considered guests and have no rights with reference to the proceedings of the meeting. Under current legislation, members of the public have a right to attend public meetings of the Commission, but they do not have a right to participate or speak unless the Commission provides the opportunity to do so. It says public comment must be respectful and avoid the use of names. It further notes that, and this is where part of the bad legal take comes in, the Commission has an obligation and a duty under the respectful workplace policy and associated legislation to ensure that they are maintaining a safe and caring work environment for all employees, which includes promoting an environment free from discrimination and harassment. And the new policy basically says this. So speakers need to register in advance, which is tough because they don't always know what's going to be on the agenda in advance. Speakers must not make allegations against, disparage individual commission members, the commission, or police service staff members, including cops. And speakers cannot make unreasonable or unfounded statements or demands, and the chair will get to decide what statements count as reasonable or not. And I really don't have a lot of faith that the commission is going to allow people to put forward the types of sharp criticism that are necessary in a democracy because the examples of the so-called offensive comments listed in this report that prompted the policy change are just so tame. So they include an allegation that a commission staff member was racist because they were previously a cop, claims that the police chief was a political hire, like aren't they always? Claims the police chief perpetuates an ongoing genocide, which is something you hear all day long on Twitter, and I'm pretty sure the prime minister has said something like that before. Claims the police chief is biased or failing in his duties, very offensive. Claims that police staff are tone deaf, skirting accountability, misleading, or gaslighting the public, incompetent, or dishonest, and allegations that police are using heinous violence and barbarism and that they're an oppressive institution. It goes on and on like this. So basically, any criticism, even the most milquetoast, will no longer be allowed under this policy if it's enforced as apparently it's intended to be enforced. So anyway, my bad legal take is two things. First, this legislation may not provide for a public comment period, but if you're going to hold a comment period, it seems to me that you have to allow speech that's a little bit offensive or else you're breaching the right to expression. And, this is clear from Supreme Court cases. Just to quote one in Ward and Quebec, which is the comedian case that we were involved in, the Supreme Court said the very purpose of the constitutional protection for freedom of expression is to protect expressions that may be unpopular, distasteful, or contrary to the mainstream. And it's also a bad legal take because, while the police commission might have a duty to employees to prevent harassment and discrimination, the types of comments made above couldn't possibly meet that definition. Harassment is repeated acts of vexatious comment aimed at a specific person, so it would have to be like the same person repeatedly attacking some staff member over and over again, which in most cases is not going to be true. And discrimination is creating a distinction based on grounds relating to personal or group characteristics that has the effect of imposing burdens, obligations, or disadvantages that are not imposed on others. And only certain immutable characteristics count, like race or gender. And I'm pretty sure that police officer or police chief is not a ground for discrimination. So bad legal take to the police commission. Christine, let's hear yours.
I love that BLT, Josh.
Good. I love yours too.
So mine relates to the power case. Now, as I alluded to at the end of my headline, some people have been critical of our involvement in the power case as an intervener because they want unlimited immunity for Parliament, even in those horrible cases of abuse of power, bad faith, and clearly unconstitutional laws. They are skeptics of judicial power who don't want the courts inquiring into the purposes of Parliament. And look, I do understand the argument. As I've said, I'm also a skeptic of judicial power, but I think our intervention was about affirming the state of the law as it has been for 20 years. And it's a narrow and high threshold for especially egregious cases. And that there must be some way for people to have been hurt to gain compensation for illegal laws. And this is a liberty-oriented and principled argument that we made at the court. And in trying to look, I try to understand the perspective of people who disagree with me. I try in good faith because I think it is important to understand. And so I've been reading a lot of the criticism. I hear you guys. I hear my haters. I do understand some of the criticism, but in going through some of these comments criticizing us for doing this case, I came across what I think is my favorite tweet criticizing our involvement. So we tweeted, it's important, this is what we posted. It's important to remember that the government wanted absolute immunity. It's an entirely principled position to believe the government shouldn't be able to get away with, especially damaging and unconstitutional laws that trample on rights. This was then retweeted by an account called the Great Canadian Bagel, which is saying what I think this is saying the quiet part of our critics' argument out loud. So the Bagel said, actually, the government should be able to do that because our charter shouldn't exist. Stop poisoning my perfectly good Westminster constitutional monarchy with ill-founded Republican utopianism. And then followed up with, in a monarchy, there's no need for a judicial veto because the king already has an executive veto. The king is also more qualified to apply the executive veto than the courts ever will be at the judicial veto. Also, the goals of the king align with that of his people. The courts do not. I love this tweet because I seriously cannot tell if this is a real hater, someone who really disagrees with it, or if it's a false flag designed to make us look good. Like Josh very well could have created this as a sock
Wasn't
puppet
me.
account, trying to like take the
Maybe it was for
most
us.
yeah, it's like the most extreme version of our critics' comments and putting it out there to show the absurdity of taking their argument to like the final conclusion, which is we shouldn't have a charter and instead we should be governed by philosopher kings, noble people who know what's best for us. And the king is always aligned with our values. So I don't know if this is a bad legal take per se. I just think if you are serious, Great Canadian Bagel, you're helping us. You're just making our point look even better. So that's my bad legal take this week.
All right, it's a good one. So that's the end of the show. As usual, we hope you'll rate us, review us, and subscribe, and do that survey in the show notes or on our website if you get a chance. You can support our work by subscribing to the CCF's YouTube channel, where you'll hear regularly from Christine, by following us on X, or by visiting our website, theccf.ca, where you can sign up for our Freedom Update newsletter. The CCF is a nonpartisan legal charity funded by your donation, so please click that donation button on our website if you can. Thanks for listening.